Thank you everyone for joining us today for our presentation on the E-2 visa. My name is Dustin Saldariaga and I am an associate at Scott Legal PC. If you're here today, you might already have an E-2 visa. You might just be curious about one, or you might know nothing about the E-2 visa and have just heard things on Facebook forums and elsewhere. Regardless, you are in the right place. Our firm was actually started on an E-2 visa 10 years ago by our founder, Ian Scott, and his experience navigating the process really does shape how we approach each E-2 visa application for our clients. Our firm does have a focus on investor visas, including the E-2 visa, and we've processed hundreds of them. Today, we'll be covering some of the fundamentals about the E-2 visa, but focusing on how to approach a case when it is considered what we call risky, which could mean, usually it means that there's a low investment amount. But it could be any number of other aspects, including the type of business, and we'll talk about that as well. A few things before we get started. This webinar is part of a series that will continue by doing at least 2 webinars a month on a variety of topics. We already have a number of webinars scheduled, and we regularly add more. At the end of this webinar, we'll be sending out to each of you the PowerPoint presentation that you see on your screen, as well as a link where you can sign up for additional webinars. This webinar is recorded, so we'll send you a link where you can find the recording. And finally, you'll see in the email we send to you a link to our YouTube channel. We post our webinars to our YouTube channel, as well as a variety of videos on a range of immigration related topics. So please do check out that link, visit our YouTube channel, and we hope you find the resources helpful. A few housekeeping items before we get started. We plan to reserve a few minutes at the end for questions, but if you do have a question that comes up in the meantime, please do send it in using either the chat function or the question and answer function on Zoom. We might be answering the question if it's particularly relevant during the presentation, but otherwise we'll get to it at the end. Again, my name is Dustin. I'll be one of the presenters for this webinar. My colleague, Jie Huang, is also joining me today. She has a wealth of experience processing E-2 visas, as well as a variety of other immigration benefits, whether that be family-based immigration. And I should also mention that our firm does cover the full range of immigration options, not just business immigration. And GA has experience in all of those areas. So we're very fortunate to have her with me today as well. So without further ado, I will go ahead and dive in by talking a bit about the E-2 visa requirements, which you see on your screen now. We'll be getting a little bit more in depth into a number of these. So for now, we'll touch on all of them so that you're familiar. The first requirement for an E-2 treaty visa, and remember the E-2 visa is a treaty visa, is that you must be a national of a treaty country. A treaty country is a country that has a treaty with the United States, basically to offer these types of visas that allow entrepreneurs or business owners from abroad to come to the US. The US Department of State publishes a current list of E-2 and E-1 treaty countries on its website. So if you Googled US Department of State E-2 treaty countries, you'll see a list there. There are about 80 countries on the list. So you do find them throughout Latin America, Asia, Africa. They really do span the globe. So check out that list if you're curious whether your country of nationality is on the list. A few countries that are not on the list, unfortunately, are China, India, Brazil, South Africa, and there are a number of others. There's an option, and what we find often happens is that individuals who are nationals of, say, China or India will get citizenship through investment in an E-2 country such as Grenada, and that would make them eligible to apply for an E-2 visa. So if you were not born in an E-2 treaty country, don't lose hope, because oftentimes there is an option to acquire citizenship through investment through an E-2 country. You must own at least 50% of the E2 company in order to apply as an E2 investor, E2 treaty investor. The moment that your ownership drops below 50%, you become ineligible for an E2 investor visa. We're not going to talk about E2 employee visas on this webinar, but if you do find that your ownership is below 50%, you might be eligible for an E2 employee visa instead of an E2 investor visa. But this presentation focuses on the E2 investor visa, and for that, you must own at least 50% of the E2 company. So that does mean that you can have a co-owner. So your co-owner can own up to 50%. So if you have two owners of a business who both want E2 visas, the only way that they can do that is if they each own 50% of the E2 company. Third on the list, you see you must make an investment in the E2 company. That means that you must actually commit your personal funds to the business. It's not enough to just move your personal funds into a business bank account and then to apply based on that. The government will want to see that you've actually spent that money on the business and on the variety of things that the business actually needs in order to operate, including office supplies and office space, including things like marketing, paying employees if you have employees, things like that. Once you've paid for those expenses, and if you can include those in your application, it is okay to have working capital, but working capital is not a substitute for actually making those expenditures. The government will also want to see that the source of the funds that were invested in the E2 business were acquired through a legal and legitimate means. This is actually quite a broad requirement. It's typically not problematic because the government is generally accepting of a range of, as long as they're legal, a range of sources of funds. So acceptable sources of funds are a gift from someone, really anyone. They can give you a gift of funds that you then invest in the business. A loan is generally fine as long as it's not secured by the assets of the E2 business. The applicant could have sold property and they use funds from that property sale to invest in the business, or income from work, for example, or any other legitimate source of income. Those are all generally fine. So it's oftentimes easier to talk about what's not allowed rather than what is allowed in terms of the source of funds. What is not allowed would be revenue that's from the E2 business itself that has not been distributed to the applicant, or a loan, as I said before, that's secured by the E2 business assets. Those are a couple examples of sources that are not allowed. The investment amount, as you see on your screen, must be substantial. We'll be talking about this quite a bit in this presentation because it's one of the most common questions that applicants have. How much do I need to invest in the E2 business for it to be okay to the government? And the answer is there's no specific answer to that question. The government does not have a set dollar amount. It really does depend on the type of business. And again, we'll talk about that more a bit later. Typical examples of E2 expenditures are, as you see on your screen, inventory, equipment, a website, office supplies, renting the business premises, marketing, or business entity setup. And this points to something that's important to note, which is that the investment amount really serves two purposes in the eyes of the government officer. First is they want to see that you've invested enough in the business to show that you're committed to it. That's part of why they want to see you've actually spent the funds. The government wants to see, okay, this person has actually put $100,000, for example, of their personal funds into this business. Therefore, I know, or I'm fairly certain, they're going to go to the US actually to build this business since they are committed to it. The other thing that they're looking for, though, is to see that the business owner has bought everything that's necessary for the business to become operational as soon as the visa is issued. And that's why you really do want to show that you've bought everything that the business needs, so that once you get that visa, you can travel to the US and really hit the ground running, growing the business, generating revenue, and eventually hiring workers. The The final note here, investment when starting versus purchasing a business. What I've been describing is typically for a startup where you'd have to invest in these range of things, but it is also possible to apply for an E-2 visa based on a business that already exists that you've purchased within the US, or to start a franchise where a franchisor will lay out the things you need to buy. Both are fine and actually might even be simpler than a startup. If you're buying a business, you really do want to purchase a business that, if it's been operational for at least a year or two or more, has been employing workers, because if it hasn't been, you'll have to overcome that hurdle and explain to the government why, even though your business that you bought hasn't employed workers in the past, you'll start doing that once you buy the business. That could be a difficult thing to convince the government of. So easier is to buy a business that actually does employ that number of workers, but we'll talk about that a bit more later as well. The fourth bullet you see on your screen is really critical, central to the E-2 application. And the reason I say that is that it really is what we would say is a make or break requirement. And that is that the business cannot be marginal. That means that the business must generate sufficient revenue to support not only the E-2 investor and their family, but also to hire US workers. And so the government will want to see that your business will likely be employing at least 3 to 4 full-time equivalent workers within 5 years of operations starting. If you can't show that, if you can't convince the government that you will hire 3 to 4 full-time equivalent employees within 5 years, it's very likely your application will be denied. On the other hand, if you have weaknesses in your application, such as a low investment amount, but you can show that you already employ several workers, you can overcome those other weaknesses oftentimes by showing that you satisfy this marginality requirement. That's why we say it really is a make or break requirement. The fifth item on the screen is that the business must be real and operating. What that means is that the business needs to be ready to operate once you receive the visa and show up in the US. It is absolutely possible and very common to apply for an E-2 visa and be approved with only a business plan, meaning that the business is not actually already generating revenue, is not already employing workers. It's fine to say that operations have not started as of the time of your visa interview, but as soon as you get the visa, you're going to come to the US and start building that business so that it generates revenue. And that's what it means to be real and operating. And things that you can include in your application to show that the business is real and operating are things like a signed commercial lease, showing that the business has been established, has a website, is already marketing, has already generated interest among prospective clients, whether in the form of contracts that have been signed or letters of interest, things like that, that really show that you're not coming to the US to just speculate about what business you want to buy. You really are coming to the US to start generating revenue at the business you've invested in. Sixth on the screen, you see you will solely develop and direct the E-2 enterprise. First of all, you must be qualified to develop and direct the E-2 enterprise. This is a low bar. There is no education requirement or experience requirement really for an E-2 visa. But what you do want to do is advocate for yourself and show how your background, whatever it is, really does position you to do what you say you will do at the E-2 business. So if you say, I am going to develop and direct this business, so that it's employing 3 workers in 5 years, you need to make the case that your experience qualifies you to do that, whether it's that you've already managed a business or you've been in the professional world for a few years and you've experienced things and have certain skills. You'll want to argue that those skills equip you to do what you say you'll do. Now, the other aspect of this requirement, which is especially important if you're applying from within the US through US Citizenship and Immigration Services or USCIS, is that the E-2 investor is not supposed to primarily be providing direct services to clients. They are supposed to be, as you see on the screen, developing and directing the business itself. Now, it's helpful to look at an example for this. a case we had not too long ago was for an accountant, and she was trained to be an accountant, had a educational background as an accountant, and she was starting her E-2 business, which was going to be an accounting firm. And she had come to us saying that she would hire her first worker in year 3. And she would have, five workers by year 5, but she wouldn't start hiring until year 3. That is a problem, because what that means is that in years 1 and 2, if this is an accounting firm, she's going to be providing accounting services to clients. And in the eyes of the government, what that means is that she's taking work away from a US accountant who was looking for work. Contrast that, and what we did was we worked with her to actually start hiring earlier. So to say, maybe you can hire a part-time worker in year 1 and start having that part-time accountant actually providing the direct services to clients. And in that way, she was able to say, I will be providing some direct services to clients, but my main job is going to be really networking, marketing, building this business so that I can hire more accountants over time. And it's not me providing the accounting services. Rather, I am an entrepreneur and I am a business owner who's growing this business. That's important because in the eyes of the government, entrepreneurs don't take jobs from other entrepreneurs. Entrepreneurs create jobs. So the E-2 investor should be first and foremost an entrepreneur developing and directing the E-2 enterprise. And again, that's usually not critical for consulates. It is critical if you're applying through USCIS, and it is still something you should take into account if you're applying at a consulate. The 7th requirement that you see on your screen is that you must have the intent to return to your home country upon the expiration of your E-2 visa. And that's because the E-2 visa is what's called a non-immigrant visa. It is not a green card. It does not lead to permanent residency. And non-immigrant visa, by definition, is temporary. So you must show the government that you intend to leave. Usually this is very easy to do. What we do is include a signed statement in applications where the applicant says, I intend to leave at the end of my E-2 visa status. And that's usually sufficient. And the other note I'll make here is that it's possible to qualify for a green card while you're on an E-2 visa in the US. For example, if you've grown your E-2 business to a point where you qualify for an EB-5 millionaire's visa, what colloquial call a millionaire's visa, or if you are in the US on an E-2 visa and you get married to a US citizen, you would independently qualify for a green card. And you could apply for a green card through either of those 2 pathways that I just laid out. What it means to say that an E-2 visa does not lead to a green card is that it's not the kind of system where step 1 is apply for an E-2 visa, and then step 2, based on that alone, you can then apply for a green card. That's not how it works. The US doesn't have a point system that some other countries have, for example. You would need to independently qualify for the green card. So let's talk a little bit more about a couple of these requirements. I won't spend too much time on this since we did go a little bit more in depth on the prior slide than I had intended. But again, the E-2 treaty investor visa is a non-immigrant visa. It allows nationals of certain countries to come to the US to develop and direct operations of an enterprise in which they have invested. That touches on a range of the requirements we talked about on the prior slide. There are several options for obtaining an E-2 visa. I already mentioned the 3 primary ones: purchasing an existing business in the US, starting a business in the US, or there's a third that you don't see on your screen, which is starting a franchise and working with a franchisor. We frequently deal with all 3 options. None is necessarily better than another. We have approvals in all 3 regularly. If you are purchasing a business, just do be careful that it's a business that's employed workers. If you're working with a franchise, it can help to work with a franchise broker. We don't have a list of specific franchise brokers that we recommend, but by doing research online in terms of an area of business that you're interested in, whether it be a restaurant or home cleaning, anything, property management. All of these are franchises that we've seen successfully apply for E-2 visas in the past. And finally, you can start your own business. That's probably the most common type of case that we see. And we'll talk a bit more about this later, but a startup really, the quality of a startup application, E-2 application, really does hinge on the business plan, because the business plan is where you'll convince the government you'll generate sufficient revenue to hire workers. And we can talk about that a bit more later. As I mentioned before, there must be a treaty between the United States and the E-2 treaty country. Check the US Department of State's website for the full list. And finally, how long is the E-2 visa valid for? It ranges. There is something called Reciprocity. You may be familiar with this because it applies to not just the E-2 visa, but a range of visas. And basically, it's kind of an agreement between the US and the treaty country in terms of how long the visa is valid for. The maximum period of time is 5 years. So for example, nationals of Canada will receive E-2 visa status for 5 years. Some countries are as short as 3 months. Regardless of how long the visa is valid for, each time you enter the US on your visa, you'll be given 2 years of E-2 visa status. So you'll be able to remain in the US for 2 years based on your visa. So just as an extreme example, let's say you're from a country that has 3 months of reciprocity. So you have a 3-month visa. Let's say you enter on the very last day of that 3-month period, you enter the US, you'd be given 2 years of E-2 status. And that assumes your passport's valid and everything else. But all things being normal, you'd be given 2 years of E-2 status. And then at the end of that 2-year period, you have a couple options. You could either go back to your home country and apply for another E-2 visa, a renewal in your home country, and get a new visa, and you'd re-enter the US based on that and get another 2 years of status on each entry. Or you would extend your status within the US through USCIS. And if you do that and you're approved, USCIS would grant you 2 years of status without you needing to leave and re-enter the US. So let's talk about this, this very common question, which is, how much do I need to invest to satisfy the government's requirement? As I said before, there is no set dollar amount. The government does not say that if you invest X dollars, you satisfy this requirement. That is the case for, say, an EB-5 investor visa, where the government has a very clear threshold. You must invest a specific dollar amount. The E-2 is not like that. And that has a good side and a bad side. The bad side is there's uncertainty. So you're not sure. You could always be denied on this basis, depending on the consular officer. If they just don't feel like you've invested enough, that is a basis to deny. However, the government has said that there is something called a proportionality test that they look at, which is the more money required to start the business, the lower the percent of that money is required. So to take an example, if you're starting a business, our company was started on an E-2 visa, a law firm, right? A law firm has very low overhead, very low startup fees, as do many service-oriented businesses like consulting firms. So those types of companies, you can oftentimes start with $50,000 or less. We wouldn't recommend that for an E-2 visa. We'll talk about that, but you could start one of these businesses for $50,000. If you are starting that type of company and you're investing, say, $50,000 or $100,000, which would be typically our minimum recommended amount to invest, $100,000, the government will want to see that you've put all of that money into the business. 100% of the $100,000 should be committed to the business. In contrast, if you're starting a business that, say, you're going to be manufacturing batteries for electric vehicles, that could take several $1 million to start up that business. In that case, the government's not going to require that you've invested 100% of that, say, $10 million. They'll say, okay, $10 million is a large amount. We'll accept 30% invested in that. So if you've invested 3 million of that 10 million, that satisfies the proportionality test. That's what that test is. It really does depend on the type of business. And a lot of the time we spend with our clients is talking about what kind of business they're starting, what a sufficient investment amount would be, really bolstering that amount to the extent that they can, and putting their best foot forward in the application. And we'll talk more about strategies to deal with a low dollar amount in the next slide. But one thing you can do, if you do have a low investment amount, and for the purposes of this presentation, when I say a low investment amount, you can assume that it's under $100,000. There are certain types of businesses where $100,000 would even be risky. For example, that electric vehicle battery manufacturing firm. But in general, if we see an application with a dollar amount below $100,000, we would take steps to strengthen that application elsewhere, or to work with the client to bring the investment amount above $100,000. If your investment amount is low, then a couple things you can do. You can include a letter from a CPA, a certified public accountant, that says that based on the type of business, you really have invested the full amount that's needed to get that business started. You can also include articles from trade publications, business journals, that say that for this type of business, the lower investment amount is sufficient. To take an example that I really like to share, I handled a case not too long ago for a client who was starting a tattoo parlor. He had invested a certain amount, and I didn't think that the government would know how much you usually need to invest to get a tattoo parlor started. It is a relatively low amount needed to get it started. So I worked with the client to find trade publications, to first learn what are the publications that tattoo artists use, and then to use those publications to find articles about how much it costs to get the business started. So we included those in the application to show that the amount he invested is normal for getting a tattoo parlor started, and that application was ultimately approved. So strategies to deal with a low dollar amount. For clients who come to us and they've invested an amount under $100,000, one of the things we always try to do and must do is look at the application as a whole. The government is not only looking at the dollar amount invested, and I referred to this before when I was talking about the marginality requirement, the requirement to employ workers. The government really is looking at the strength of the application as a whole. So if the investment amount is low, the first question we would ask is oftentimes, first of all, can the investment amount be increased? But if the answer is, I really have invested everything I need to in the business, then the next question is, okay, what are other areas of the application that we can strengthen or focus on? And oftentimes it is that employment aspect that we would really want to focus on. If it's possible for the applicant to hire a worker, even a part-time worker, then that really does strengthen the application. So if you can show, I've invested less than $100,000, but I'm already employing a worker who's already doing work, and I already have interest from clients or prospective clients. And it would be great if you were already generating revenue too. You could show all of those things. And if you're able to show those things, then the government is less concerned that the amount you've invested won't lead to a viable business, because you already have a viable business that's employing workers. So think about how you can situate and really position your business so that any concerns the government has about a low investment amount, you can say, well, it is low, but look at all these things that I've been able to do in spite of that. And again, I referred to this, but strong real and operating evidence to show that you already have contracts with clients or letters of intent from clients. You can also include letters from the local chamber of commerce saying that your business is likely to generate interest and there will likely be demand. A strong business plan and evidence that you've hired U.S. employees. I touched on that before. That really can make or break a risky application. You see a couple examples. These are a bit extreme, but just to take example one, you're opening a business, low investment amount. However, you've already hired two U.S. employees, and the business has already started taking in revenue, and you have 10 clients. That could still be a strong application. And you really would want to emphasize that in spite of the low investment amount, you're already generating revenue. The business is already operational. Contrast that to the second example, which is you're applying for an E-2 visa. The investment amount is low, However, you don't want to invest any more money, and you don't want to, or there's not an opportunity to hire anyone until the visa is approved and you come to the US. That is an especially risky application. You really are going to need to convince the government that not only do you have a low investment amount, but this is really a business that promises future growth. You would need to do that usually through the business plan first and foremost, showing really reasonable assumptions and high projected revenue over time and projected employment figures. But you could also compensate that second example by going to your local chamber of commerce, getting a letter from them, getting letters of interest, things like that. You would really think creatively about how to advocate for yourself. But again, example 2 is an uphill battle. That's going to be a tough one. So really do think creatively about what you can do if you're in that situation. We've already talked a bit about common E-2 visa expenditures. If you have a low investment amount, again, our first step is usually to work with the client to see if they can boost the investment amount. Some of these, there's really not much of an opportunity to boost the investment amount. For example, you're not going to be able to boost the amount you spend on setting up the business entity. However, things like marketing. Marketing is an area where the more you spend on it, you generally tend to increase your returns on that investment. That is an investment that leads to increased returns. So marketing, improving your website, getting more Google ads, getting more Facebook ads. That's an area where you can put more money into that, put it on your investment schedule and boost your investment amount, while not just throwing money at the business that's not going to have a return. Another opportunity is oftentimes in the lease. Sometimes it's possible to get a slightly nicer office, an office that is not only a dedicated desk, but a dedicated space within a building. Oftentimes, applicants are able to pay for their lease in advance, so they can pay 6 months in advance on their lease, and that can be included in your investment schedule and really boost the investment amount. So think creatively about whether any of these examples on your screen are areas where you could spend a little bit more and actually see returns for the business while boosting your investment amount. There are some bad or weak E-2 expenditures. You would not want to include expenses paid to travel to the US, to look at businesses before you've actually decided on one, for example, with a business broker, hotel accommodations, meals, entertainment. Don't include any of that. Not only will the government likely discount it, it raises questions about the E-2 investor's judgment. Why are they including these in the application? Are they trying to pad the application? And you just don't want to create questions about the integrity of the application. So leave out these weak expenses and really focus on expenses that directly benefit the business. So now we'll talk about a couple areas of E-2 businesses that are particularly risky just by the nature of the business itself. The first is consulting businesses. Now, the reason that consulting businesses tend to be risky is that they are not expensive to start for the most part. But that being said, a low investment amount can be sufficient to start a consulting business. When I say consulting businesses, law firms are oftentimes in the same category. Law firms are relatively inexpensive to start and run into many of these same hurdles. So these strategies would apply to law firms, consulting firms, and really any business that does just the nature of it doesn't require much by way of startup expenses. You remember that what the government is looking for is to see that you're committed to successfully operate the business. So even if your business doesn't require a lot of money, the question is, how can you show to the government that you really are committed to successfully operate the business? Put yourself in the officer's shoes and imagine, say that you have a friend or a family member who comes to you and says, I'm thinking about I'm thinking about starting a business in the United States. and you're trying to figure out how serious they are about that proposal, one of the first things you do is say, okay, well, what have you taken any steps to do that? If they say no, it's just an idea, or well, I've put money into a bank account, that doesn't show a lot of commitment. They can always transfer that money out. They can always abandon the idea. But if they say, well, I've actually bought the business, I've actually spent money on the business, I've actually committed myself to a 6-month lease, that starts to look a lot more like a real commitment. And the government officer thinks the same way that we do, that a typical person would. So think about that. The examples you see on your screen, think about whether you can prepay for office space. Think about whether you can buy additional equipment, maybe an additional computer if you're thinking about hiring an employee and that computer will actually be useful. Like I said before, invest in marketing for the consulting business. And really key, if it's possible to hire an employee, do it. That really is something that can significantly strengthen the application. And I think, I've said that a few times on this presentation, so I really do hope that it's a key takeaway for you all. The other type of business that oftentimes faces challenges is real estate investment businesses, and really any investment business. The reason is that the government does not consider speculative businesses. And what I mean by speculative is where the purpose of the business is to put money into something with the expectation that that thing will grow in value, whether the business is investing in real estate, hoping that the real estate value will increase, or if the business is investing in stocks, which we'll talk about in a moment. Those types of businesses are not strong with respect to E-2 visa applications. And the reason is the government is not convinced usually that that is the type of business that will hire workers. Passive businesses oftentimes don't require employees to actually be employed by the business. So if you have a real estate holding company, it typically will not qualify. You need to do more. You have to show that this is a real and operating business and not simply a speculative investment. So things you can do is create a business, a real estate business that does require workers. So this can be property management. We see property management companies are frequently successful at receiving E-2 visas because if you're managing property, you need employees to do that, people to actually go to the space, people to do repairs, people for security, things like that. You need an accountant oftentimes, you need administrative people in your business. So there's a really good argument for property management companies that you actually do need workers. So the same is true for the other examples you see on screen, real estate renovation or construction businesses, real estate brokerage firms. Again, you always want to focus on the fact that your business needs workers and that you'll actually employ them. House flipping can be tricky because house flipping the government often does see as a speculative or idle investment. So if you're applying through with a house flipping business, you really would want to show that the business requires workers. So that is key. And one of the ways to do that is to increase the scale of the business. So if you have a house flipping business that has 20 homes versus say 2, that's going to result in a stronger E-2 application because you have a stronger argument to show that you need workers. Now, for equity trading companies, the same is true as with what I said before regarding real estate holding companies. Equity trading companies are also risky because you basically have to overcome the government's assumption that the business is idle and passive and speculative. Placing stock in a portfolio in the name of an LLC is not going to satisfy the E-2 requirements. So what you need to do is you need to show that you really are building a business that will generate a revenue and that requires US workers. So you can do that by showing that your clientele will go beyond your friends and family. You'll also want to show that the equity trading company will have enough activity that it is to show that it's an active business and actually does require additional employees, accountants, other traders, people like this. And finally, keep in mind that the equity trading sector is highly regulated. So you do need to get certain certifications in order to operate in that space. And part of the real and operating requirement that we looked at before is showing the government that you have all the required certifications for you to come to the US and actually operate this type of business. So include the proof that you have those certifications in your application. Some common reasons for E-2 denials, we've talked about at least the first two of these. So low investment amount is a very common reason for E-2 denials. And for that reason, when someone comes to us and they either have not invested much money or they've applied on their own or with someone else and have faced a denial based on the low investment amount, we work closely with them to see if they can invest more or strengthen other aspects of the case. This really is a key flag for the government when the investment amount is low. But there are ways, as you've seen in this presentation, to address that. The nature of the business can also be a reason for a denial. We talked about real estate, holding companies, equity trading companies. Those are risky types of companies. So the nature of the company could make for a weak E-2 application. The filing location or the venue can also be a flag, be a source of weakness. There are certain consulates that simply want to see a higher investment amount, and that could be because most of the E-2 applicants they see are multinational companies. So they're used to seeing large revenue figures. And when someone comes with a startup, they think it's a low investment amount. Other consulates are less strict about the investment amount. So this really does change location by location. We file applications around the world. So part of our strategy is figuring out which location is the ideal place to apply. And you know, when speaking about location, whether to apply within the US is also an important strategic consideration. USCIS, for example, is not as strict about the investment amount. They tend not to deny applications based solely on a low investment amount. On the other hand, they are extremely strict when it comes to proving where the funds came from. So if you've invested a relatively small amount of funds, but you can clearly show where those funds came from, applying through, and you're within the US, USCIS could be the best option. In contrast, if you've invested a lot of money in the business, but you have very poor documentation, you could face a denial at USCIS, so you might want to apply at a consulate abroad, which is less likely to dig into the source of funds documentation. Another common reason for denials is if the applicant has a business in their home country that does not have employees. For example, we oftentimes have clients who come to us saying, I want to start a business in the US. I already have a similar business abroad, so I'm just going to create a location in the US. One of the first things we'll ask them is, how's the business abroad doing? If it turns out that they've been operating the business abroad for a few years and it hasn't hired any employees, that's a flag to the government. So it's not insurmountable, but what you would have to do is to convince the government that you'll do things differently in the US. You're going to take several concrete, very specific steps so that the business in the US will employ workers, whereas the business abroad didn't. And that's the same principle that I was talking about before with respect to buying a business in the US. The track record of the business really does matter. If the business in the US hasn't employed workers, the government's going to want to know why and what you're going to do differently so that you do hire workers when you're on an E-2 visa. Another common reason for denials, a denial is concern over whether the business will create jobs for US workers. We've talked about that. The marginality requirement, it really is key. So you want, if you have a startup, you want a really strong business plan that has good financial assumptions about what the business is going to do, going to generate in revenue, and how many workers it'll hire. Issues with the adjudicating officer. Frankly, at consulates, consular officers have a huge amount of discretion. They, in general, can deny for any reason, and their decision cannot be reviewed. There's no appeal process. So they have a lot of power, and frankly, sometimes you just draw a bad officer, an officer who's having a bad day. So there's really not much you can do about that. You do generally have the opportunity to apply again. But that being said, like I said, we file a lot of these applications. We very rarely run into officers who deny for no reason. Usually there are weaknesses in the application that we generally can work with the client to address them. But some things are simply insurmountable. And the best that we can do is let the client know you have these risks in the application. We can go forward in spite of that, but you might have an issue with that. That's usually the worst case scenario. We rarely have issues with officers who just deny for no reason, but it does happen. So you need to be aware of that. And finally, sometimes applicants simply do not meet the E-2 visa requirements at the time of filing. By and large, that doesn't happen with applications we file, but we do work with people who filed either on their own without an attorney or using outside assistance. And when we look at the application, sometimes there's simply is not sufficient evidence that they've satisfied the requirements. So when they apply again, they really do need to make sure that they have satisfied those requirements. So let's talk about a few E-2 visa trends. The Biden administration has been in office for a couple years now, and there were a lot of questions about whether in comparison to the prior administration, we're going to see significant improvements in terms of E-2 visa approval rates. The answer is we frankly, in the context of E-2 visas, we have not seen a lot of change. That's both good and bad. Good because the prior administration, the Trump administration, didn't really deliberately restrict E-2 visas. E-2 visas are for entrepreneurs who are supposed to create jobs in the US. So usually Republicans and Democrats like E-2 visas. So we didn't see a ton of hostility toward E-2 visas over time. And so that's continued with the Biden administration, where they also continue to adjudicate and approve E-2 visas with regularity. The approval rate, on the negative side, the approval rate, or I should say the approval rate has remained constant. On the negative side, adjudications have not gotten faster. And that is extremely frustrating for everyone involved. By and large, consulates around the world and USCIS domestically are all facing enormous backlogs, historic delays. So if you are applying, keep that in mind. You are probably going to be waiting months for a consulate to call you in for an interview and give you a visa. We work with clients a lot figuring out whether certain consulates are faster than others, and some are. Consulates really do vary in their adjudication times. Right now, I think that 4 to 6 months is a helpful time frame to have in mind for how long it'll take between submitting the application and actually being called in for an interview. But that really can vary. Certain consulates we have seen call clients in within 3 weeks of the application being submitted. That does happen, not often, but it does happen. Other consulates can take over a year, and unfortunately that does happen as well. So we work with clients to figure out what consulates might be faster than others. And there are oftentimes ways to expedite an application. You can file, in general, expedite requests with the consulate explaining why it is urgent to come to the US. Those are not necessarily always granted, but it is an option to get these applications moving. All right, Baja is is not extremely relevant anymore. Basically, it is important to, if you're applying for an E-2 employee visa, to show that, you know, there are not domestic workers, although Baja no longer exists under President Biden's administration. So, less important at this time than it was a few years ago. Consulates are currently processing E-2 visa petitions. Timelines are long, as I said before. And as a result, many more applicants have decided to extend their E-2 status within the US rather than leave and apply through a consulate. You can, if you have E-2 status within the US, or if you're on another status and you want to change status to E-2 status within the US, you can apply for E-2 status using premium processing, which is something that USCIS offers that guarantees a decision in 15 calendar days. It's very fast. It does cost $2,500. It goes to the government. But for many people, that is a great way to, if you're within the US, to start operating your business quickly. One note, if you do get E-2 status within the US, it does not give you the ability to travel. So status within the US is not a visa. So let's say you're in the US on a student visa, you start a business, you change to E-2 status from within the US, do not go to a consulate and get a visa. USCIS gives you 2 years of status. The moment you leave the US, you need to apply for an E-2 visa. You can't come back in E-2 status. So for that reason, we do generally prefer that and recommend that our clients apply for an E-2 visa at a consulate. You can apply for both simultaneously. So you can apply for that premium processing with USCIS so that you can start working on the business within the US, and at the same time file an application with the consulate so that, you know, 4, 5, 6 months from now, when you're called up, you get to leave, get your visa, and then you can come in. That is something that happens quite often. And finally, some issues in complex areas that come up with E-2 visas. We've talked about this first one extensively. The answer is yes, you need to hire employees within 5 years of applying for an E-2, within 5 years of the business being operational. You do not need to hire employees before you apply for an E-2 visa. In that case, you really do need a strong business plan to convince the government that you will hire employees, even though you have no revenues, you're not operational. Perfectly fine, but you want a strong business plan to convince the government. Complicated source and trail of funds. This is especially relevant for USCIS filings where they really scrutinize the source of funds documentation. Loans are fine and gifts are fine. If you're using a loan, it cannot be secured by the assets of the E-2 business. You also cannot use business revenue from the E-2 business that's retained earnings. They have to be distributed to you. You have to pay tax on them, and then you can invest them into the business. But you can't simply say, you know, I have a business that's been running for 10 years, and based on its revenues, I'm investing the retained earnings, I'm investing that into the business. The government will not accept that. Gifts are fine. Really, you can have a gift from anyone. The thing about gifts is that you do need to show where the person who gave you the gift got the money. So if you have a brother-in-law who's worked for the last decade to save up $100,000 that they then give you, you need to show those tax returns. You need to show that the brother-in-law really did work for that period of time to earn the money and then transferred the money to you. You need those bank statements showing your receipt of the funds, especially with USCIS. That's critical. As I mentioned before, you can apply for E-2 investor visas for 2 investors. The only way to do that is if they each own 50% of the business. And in general, they should invest about the same amount of money into the business. That makes for a simpler application. If they haven't, there are ways around that. You'd want to work with a qualified attorney. It's recommended if you're in that situation, because it can be a little bit tricky. Finally, substantive changes to the E-2 business after filing. Sometimes people apply with one type of business and over time the business changes. For example, if they apply to run a restaurant in the US, they have an E-2 visa to do that, but then they decide to start a software consulting company. That's not like a restaurant. So the government is going to see that's a substantive change. You want to make sure to get approval from the government before you make that change and start working on that software company. Otherwise, you could violate your visa status, and that could be very bad. So if you're thinking about changing the business, in general, err on the side of caution and get approval from the government beforehand. On the other hand, if you are operating a restaurant and you want to start a little coffee shop, it's probably fine. It's a similar business, but this is an area where it can be helpful to talk with a lawyer who's seen a number of these cases and can advise you as to whether your change is actually substantive. Changes in ownership really can be critical because, again, the E-2 investors' ownership cannot drop below 50%. The moment their ownership drops below 50%, they lose their status. Essentially, they become they cease qualifying for E-2 status, and technically they are required to stop relying on their status. So you want to make sure that your ownership stake does not drop below 50%. As long as it's above 50%, it's generally okay. If your ownership stake changes, but you just want to make sure you have at least 50% ownership. And finally, family business purchases. It's possible to buy a business from a family member. You want to be very careful to show the government that the transaction and the amount that you paid for the business is still the fair market value. That if the business were marketed on the open market, you paid the amount that the seller would likely get. And so if you can show that the family member did put it on the market for a certain price, that's great. You also, it shouldn't appear like you got a discounted rate for the business. You really do want to show you paid the fair market value. All right, and questions and answers. And GA, I think you are here.
Yeah.
So please feel free to chime in with any questions.
Yeah, that was so great. Thank you so much, Dustin. I do think we have a lot of questions from the audience today. So maybe let's just quickly go through them. I think the first question I think we could go is the first one, actually. There was a specific question of someone who wanted to buy a tax preparation franchise, and the franchise fees comes down to $40,000, $30,000 expenses for office and computer. Is that risky or enough?
That's a good question. On the face of it, it would raise flags just because $30,000 to $40,000 is not a large investment amount. That really would be at the lower end of really any application that we would submit. So I would first say, look for opportunities to increase the investment amount. For example, it might be possible to pay for your office space in advance. If you can pay for 6 months or a year in advance, do that. If you have some discretion over the computers you can buy, if you can buy an additional computer showing that for the purpose of an additional employee working for you, do that. If you can invest in marketing, additional marketing above and beyond what the franchisor requires, do that. That would be the first step. But the second step is really to look at the franchise disclosure document, the FDD, which usually lays out exactly what the first year expenses are. And I would take a look at that and see what is included in that $40,000. It would seem that not everything's included just because the amount is so low, and you can find ways to bolster it. But if that agreement does show that everything is included there, then you are in a slightly better position than if you had a startup and had invested $30,000 to $40,000, because a startup, there's no franchisor in the picture saying this is what usually works. A franchisor, if they're saying $40,000 gets this business operational, that does carry some weight, but there are still flags. So I would say still really try to find ways to bolster that investment amount.
Another question that's related, what if somebody already owns the assets like computers, office furniture, or etc.? And my take on this is that if you have the receipts from when you purchased it, and if you're using those assets towards the business, you can include them in the investment schedule. What are your thoughts, Dustin?
Yeah, I think that's right. I mean, if you, for example, I mean, there's kind of a spectrum. I think, if you've owned a computer, like I've had my MacBook for about 6 years. So if I wanted to start a business and I put in my receipt for my MacBook 6 years ago, and I'm starting the business this year, that would look odd. And I wouldn't include that. But if I bought a MacBook, this year or last year, and it is going to be my dedicated computer for the business, I might consider including that. I think the thing that's important to keep in mind, though, is that you do need to track the source of funds. So, for example, if I wanted to include my MacBook from 6 years ago, I need to show where I got that $1,000 6 years ago. And that opens up a new area that, again, looks odd. Why is he showing us where he got $1,000 6 years ago? It's a little strange. So the answer is you can do it, but keep in mind the source of funds requirement, and also try to avoid things that raise questions on the government's end. That being said, if you're looking at an expensive asset like a vehicle, there are certain businesses that need a truck. And if you own a truck, $20,000 truck, and you want to include it, you might take steps to get that documentation and show that you actually did buy that truck.
All right. So the next question maybe that can be helpful to discuss is, can workers be independent contractors? And my take on it is yes, but it is generally preferred to have full-time employees. What are your thoughts, Dustin?
Yeah, that's exactly right. I think of the workers on a spectrum. The government prefers to see full-time W-2 workers. And the reason for that is they tend to be paid benefits, health insurance, retirement. Same is true for W-2 part-time workers. They tend to receive benefits as well. And the other thing about it is that W-2 employment tends to mean long-term employment. It's less likely that a W-2 employee is going to leave, in a short amount of time, versus an independent contractor. An independent contractor, usually they're shorter term, and usually they don't receive benefits. So the government wants to see W-2 workers, ideally. Independent contractors can be fine, and the government will consider them. But again, if you're using an independent contractor, I would encourage the applicant to also have at least one W-2 worker, ideally more, and then to supplement that worker with an independent contractor. And if you end up still using the independent contractor, then if there are ways to show that they are a long-term independent contractor, that's great too, to show that you're repeatedly and regularly creating work for this person. Those are the kinds of things that the government wants to see. But the answer is yes, you can use independent contractors. They're just, as GA said, slightly weaker than W-2 workers.
All right. We do have some more questions that we can go through fairly quickly, I believe. So if purchasing a business, what is the preferred order of operations? Find a qualified business to purchase and then apply for E-2, or vice versa. So here, yes, you would first find a qualified business to purchase and get the operations ready, to get the business ready to go, and then apply for the E-2. That is the order of operations we would recommend. Can we clarify the 50-50 ownership? It sounded like that is only feasible if both 50% partners were applying for an E-2. Can I not buy 50% of a company owned by a U.S. citizen and use my 50% ownership towards the E-2? For this one, you're correct. So both 50% partners need to be applying for the E-2. And if you are buying a if the company is owned 50% by a U.S. citizen, that would not work. We would recommend that you have 51% or more, so that the business has the nationality of your nationality.
Gee, I'm going to jump in real quick. So the first part was correct. The requirement, fortunately, is really just that 50% requirement. So as long as you own 50%, it really doesn't matter who owns the other 50%.
Oh, got it. Yeah.
As GA was saying, though, you want to be very careful that your ownership doesn't drop below 50%. But it is possible if you own 50% and a US citizen owns the other 50%, that's perfectly fine. Could be a green card holder, could be someone from a non-E2 treaty country. It would just be that you would be the only person applying for the E2 visa, investor visa, which is fine. If you're the only one who wants the E2 visa, then you only need to own that 50%.
Right. And another quick question that was here: when you file for an E2 spouse, yes, you do need to be married, and you need to provide the proof such as a marriage certificate in order to apply for the E2 spouse category. All right. And if you would like to discuss an E2 application with us, please feel free to schedule a consult. We offer 30-minute or 1-hour consults, and we'll be happy to discuss any questions you may have specifically about your case. And pizza franchise fees for $67,000. I think we have, went over the relevant considerations that go into judging whether amount is enough. So I would say, please, we will also be uploading this webinar as a recording. So you can refer back to the examples we discussed earlier. Dustin went in detail about some of the examples, so that will certainly help you in navigating this answer.
Perfect.
All right.
Yeah, and absolutely happy to talk with anyone through a consultation. And Gia, I think there is just one more, and forgive me, I might have missed it.
Oh, yes, I also missed it. The 2 years admissibility if you enter the US on the day before E2 expiration. And my understanding is that if you enter the US that day, you would get 2 years from the day you enter. Isn't that right?
Yeah. So that's generally right. It may have been your experience to the person asking the question that CBP will limit the entry to the visa validity, but that is not actually the way that it is supposed to work. You are given 2 years of status each time you enter on an E2 visa, even if your E2 visa expires within that period. That's different from expiration of your passport. So oftentimes CBP will limit the I-94 to the validity period of the passport, but it should not happen with respect to the visa validity period. Great, Gia. Were there any other questions you saw pop up? I think you were.
No, I think, yeah, this is definitely everything. And I think we definitely covered a lot of the things that potential clients may be interested in. So I think this webinar was very, very helpful.
Good. Well, Gia, thank you so much. And thank you to everyone for taking the time today to join us. As I said at the start, we'll be following up with the recording and with a link where you can sign up for future webinars. So please do join us in the future. And also our YouTube channel, we really do put a good amount of time and effort into that, as well as our blog. And our goal is really to make high quality information free for you all. So please do check that out as well. GA, thank you again. And to all of you, have a great day. We hope to see you again soon.